So, very good evening, my dear friends. Yesterday we were dealing with the directors. So, I have told you that the definition part is under section 234 and it has to be read with 259, 260 and section 149. And then, where any person with whose instructions the board is habituated to act upon would be deemed to be the director of the company. And in consonance with that, the particular officer in default, and then other aspects under 149 also have to be taken into account with regard to understanding the concept of directors. And I have already told you about the definition part. Now, there are different types of directors. That is what we have to see further. That is, inside directors, one such concept is, that means the whole-time director, managing director, executive director and such people are inside directors. And there are outside directors who are part-time directors and then they are not associated with the day-to-day affairs, but the inside directors are associated with the day-to-day affairs of the company. Then friends, the financial institutions nominate certain directors, they are called nominee directors. And there are certain full-time directors which are called special directors, and they may not be the members of board of directors. Here, directors means who are members of the board of directors under the provisions of the Companies Act. We have to see that particular aspect as to appointment, removal, qualifications, disqualifications, powers and duties of the directors. Then the last category is under section 149, independent directors. That particular aspect I will deal with elaborately at an appropriate time. Then friends, now apart from that, there are directors appointed by the National Company Law Tribunal and then the government and so on and so forth. There are all the different classifications or classes of directors who are in fact appointed as part of the board of directors in the affairs of the company. Then friends, the actual governance structure of corporation is like this. A company is prima facie governed by the majority decisions of shareholders, first versus hot bottle. And then the shareholders elect directors and the directors appoint the managing director, along with the general body. And under him, the shareholders, board of directors, managing director, the company secretary and other officers of the company. This is how the structure goes on. Well friends, an important question is as to the legal status of directors of the company. What is the legal status? Legal status here means that are they owners? No. Are they partners? No. Are they agents? Yes. Directors are agents of the company. While dealing with the lifting of corporate will concept, I told you, if the directors are agents, it is permissible. If the company is the agent of the shareholders or directors, then corporate will be lifted. And the directors and shareholders will be held personally liable for all the debts and the actions of the corporate entity. This is what I told you earlier. Same is the case. Directors are agents of the company. Company can never be the agent of the company. This is the most important concept of corporate governance you are supposed to understand. Then friends, the next important thing is the definition part. The director, I already explained it. Prima facie, it is very difficult to define a viable definition. I have given you a possible definition taking into account the functions of the directors of the company. Then friends, in fact, the judges in various cases define the directors as agents, as trustees, and in some extraordinary cases as managing partners, which has no statutory base. So you can say the directors are the agents and as well as trustees of the company. In fact, trusteeship comes into picture and then the various judgments will have to be observed in this particular context. Lord Justice Bowen, an expert in company law matters, has defined the directors with regard to agents. Take down what he says. Directors are described sometimes as agents, sometimes as trustees, and sometimes as managing partners. But each of these expressions is used not as exhaustive of their powers and responsibilities, but as simply indicating useful points of view only, from which they may for the moment and for the particular purpose be considered. Depends upon the circumstances of each case. Now friends, we will examine the directors as agents of the company now. Now, which is the law governing agency? Indian Contract Act. So who is the principal here? The company is the principal. Who appointed directors? The company, the shareholders in the majority, in the meeting by majority. So naturally, the company is the agent, principal, shareholders are agents. In that event, the relationship is here agency and principal. So the company is to be taken as the principal and the directors are to be taken as agents of the company. In that event, my dear friends, the true position is to be taken as that of the agent, and apart from the provisions of the various company laws relating to company and then other corporate laws, which in fact bind them, confer certain rights upon, impose certain obligations on the directors, and make them liable for defaults, for violation against the compliances. This particular relationship with the company is governed by the arrangement of agency as enunciated under the Indian Contract Act 1872. So friends, the position was well established long ago in the case of Ferguson versus Wilson. Ferguson versus Wilson. 1966. LR 2 Chancery Division, where it was held that the company, you can take down please, the company itself cannot act in its own person, for it has no person. It can only act through directors, and the case is, as regards those directors, merely the ordinary case of principal and agent. Wherever an agent is liable, those directors would be liable. Where the liability would attach the principal, then the principal, that is the company alone, is liable. So, in this particular case, the facts are very interesting. 1F, in this case, applied for certain shares, and by board resolution, the company has allotted certain shares in a railway company to F. Then at the time of allotment, all the shares in the company had been ultimately allotted to various persons, and in the result, the company could not allot any shares to F, so the company expressed its inability to allot the shares to F and then register in his name. Then F sued. But F did not sue the company. F sued the director of the company and sought a direction that the director must transfer some of his particular personal shares so that the resolution would be complied with. Now the court of law said it is wrong. Here, the resolution was made in the company, and in his personal capacity, the director did not agree. So, question of the director alienating his shares will not arise, and then there is no duty casted on the directors as agents of the company to transfer their shares and incur any personal liability. It is the liability of the company. Probably he can sue the company, seek compensation or such and such relief, or company may tomorrow increase authorized capital and allot, but that is a different aspect. Share, the director cannot be forced to put forth transfer his personal shares because of this particular resolution made by the directors of the company. That means whatever is done by the directors here, in the question of agency, the principal is liable, the agent is not liable personally because he has done it in the due course of activity of the corporate entity. This is the most important point, jurisprudential perspective, which is otherwise technically called the corporate jurisprudence. You are supposed to understand. Now, friends, Lord Justice Cairns, CIRNS, in fact, has stated so here that the company itself cannot act in its own person. Hence, it can only act through directors. And the case is, as regards those directors, merely the ordinary courts of principal and agent. Hence, personal liability would not come into picture. And here, there is another interesting case. The directors as agents can make the company liable even for contempt, and the directors are not personally liable. The directors are personally liable only in the event of lifting of corporate veil, which I have already told you, and 16 cases I have circulated to you already. You have to understand those particular 16 cases thereon. So, in this context, Vineet Kumar Mathur versus Union of India, a very important judgment of the Supreme Court, 1996. Vineet Kumar Mathur versus Union of India. You can get the citation in the internet. Supreme Court 1996. Please check up in the internet, you will get the citation. And the Supreme Court in this case directed that a company must be closed on 15 January 1993 its company on 15/1/93, and the plant has to be closed with effect from 1/4/93. The order was given on 15/1/93 to close down the unit with effect from 1/4/93, as the Pollution Control Board refused to certify. Now what happened? The company continued with the plant during 7/4/93 and 11/4/93. It attracted contempt of court. Then what happened? The company was fined by the Supreme Court to the tune of 5 lakhs. Directors were not fined. Directors were not punished. They were let off. So friends, this is the most important aspect you have to understand, that in this case, directors were not, in fact, liable, and only the company is liable. Then when the directors are liable and they incur personal liability, now this is the most important aspect, my dear friends. The directors are personally liable under certain specific circumstances.